Good afternoon, Your Honors. May it please the Court, Jonathan Mann of Law Offices of Robin Bresky, here on behalf of the appellant, Brian Ehlers. I'd like to reserve 3 minutes time for a rebuttal, if I could. We're here today requesting that the Court reverse the trial court's grant of summary judgment in favor of the appellees in this personal injury case because the appellees could be liable if they should have anticipated or foreseen that a person might be injured by the dangerous condition on which the plaintiff was injured in the case at bar. Summary judgment evidence in this particular case supports the suggestion that people in this neighborhood commonly used the swale where the plaintiff was injured for riding dirt bikes, like the plaintiff was when injured, and for parking. Now, I want to stress, and the map of this particular property is helpful.
Why is parking relevant to dirt bikes? I mean, you're not going to be driving at the same speed. There's not the same ability to injure yourself. Maybe you could hurt the car, perhaps, but I'm not sure why do you think that's relevant?
I think it's relevant because, okay, so the testimony was the plaintiff was only driving this dirt bike at 20 miles per hour when he struck the stump and was injured. If people are parking on the swale, and people are bringing vehicles onto the swale, I think it's still reasonably foreseeable that they're going to be bringing possibly motorcycles, mopeds, and dirt bikes if they're bringing cars on and off of the swale.
There was some evidence, wasn't there, that people did ride ATVs on the swale, wasn't there?
Correct. So there was evidence that people would ride dirt bikes, which is the exact activity that we've got from the plaintiff doing when he's injured. That's the neighbor. Yes, the neighbor. His name's Joseph Chiappa, and his testimony is clear. First, he testifies about this swale that in the general area, people ride dirt bikes, they ride bicycles, they walk. But then he's asked, and as to specifically this grassy swale area where the plaintiff's injury occurred, and he says, they ask him, in the area that depicts you standing in the grassy swale, he's being shown a photo of himself in the swale, says, I know counsel asked you if you observed people riding this particular area, but my question is, have you ever observed individuals riding dirt bikes or motorized bikes on the grassy swale area that's depicted in Exhibit 4 where you're standing? Answer, yes. Question, people do that? Answer, yes. That testimony...
Counsel, I have a question.
Yes, sir.
So that activity that they're doing, riding the bikes, isn't there an ordinance against that? So it's illegal, correct?
I looked into it. I'm still not entirely clear. The ordinance refers to Chapter 316.
I'm talking about a municipal ordinance, 7102A.
Right.
It says that it makes it unlawful for a person to operate a motor vehicle on any unpaved or public property. So isn't the swale unpaved public property?
It is. The ordinance refers you to a Florida statute, and it depends on then it gets into whether or not the dirt bike constitutes a motor vehicle, which I think is a defined term under the Florida statutes.
Even for a DUI, isn't a bicycle a motorized vehicle for DUI purposes? So a dirt bike wouldn't be?
I'll be honest, I'm not sure. But
Go ahead.
But I will say it doesn't change the thrust of my argument here that
Did the judge decide this on the basis, or can we say that the judge decided this on the basis of whether or not the city knew or should have known of the use of its property, or was it based upon the Wolf standard that's saying even if it did, this is an issue of landscaping?
the order does not specify, in the transcript on summary judgment, the ruling doesn't make clear what the judge's rationale behind the ruling was. But we also had the deposition testimony from Xavier Leal, who is an employee of the city. He testifies he also knows that city trucks, and then he also says cars would park there, and that he used to park there on that swale when he was a member of the, one of his previous positions with the city. He used to park there. On the day that the plaintiff was injured, the plaintiff testifies in his deposition, there were cars parked on that swale on the day that the plaintiff was injured.
Okay, but counsel, how, and I'm getting back to Judge Levine's question, how is parking on the swale the same as, I mean, there's no statute that says, or ordinance that says they can't park on the swale, correct? So how is parking on the swale related to riding a dirt bike on the swale?
You know, the appellees want to take the position that, to characterize what Mr. Ehlers was doing at the time of his injury as a, you know, he's engaged in an extreme sport. He's just tearing up and down this swale at high speeds. Like I said, he was only going 20 miles per hour at the time that he struck the stump.
Wasn't there evidence he wasn't wearing prescription glasses also that were required? I thought there was evidence in the record about that.
I don't recall that evidence, but I think it would go to a question of, that would be a question for the jury if it went to a question of contributory negligence.
So your position here is there's a disputed issue of fact as to whether or not the city had knowledge of their property being used for the purposes of all kinds of activities, including ATVs.
Most importantly, including the dirt bikes being used on the swale, because
Okay.
that's what the plaintiff was
Okay.
doing when he was injured.
Okay.
I mean, and it is that evidence that we contend, you know, means that, or supports that the defendants should have anticipated or foreseen that someone might be injured in that activity. And of course, we distinguish this case from this court's decision in the Wolf versus Sam's East case, in the same way that the third DCA in Grimes versus Family Dollar distinguished it, was that in the Grimes case, the third DCA distinguishes Wolf and Dampier and some of the other cases that Wolf had relied on by saying, well, you know, in those cases, there was the area was not being used for foot traffic, like the plaintiff had walked across a landscaping area and fallen. But then in Grimes, the court says, well, you know, the property was being used this way.
I mean, we have some of the pictures, and I don't know how many we've got, but is this, obviously in Wolf, we were dealing with a landscape. They had trees, they had this and that and the other thing in it, and it was like a buffer where there's trees and plantings and things like this. Is this maintained in that way, or is it just kind of a grass area I mean, is it to beautify the city, or is it just something they're not using? I mean, can you tell? Or is there a disputed issue of fact as to how it was being used?
I think there's a disputed issue of fact as to how it was being used. The map shows it is directly across from a city park. It's 4 baseball diamonds, and there's an entrance right there on Charleston Street. There's the testimony that cars park there for people to go to the baseball games. And so that's, again...
So counsel, okay, let's assume that it's important that the cars are parking there. So if cars are parking there, wouldn't that be even more of a reason for the ordinance violation to be a problem? Because they could be hitting people that are parking. I mean, I keep on going back to 7102 of the Hollywood municipal ordinances, which specifically prohibits operation of a motor vehicle on unpaved public or private property. So if there's people walking to a baseball field, the fact that you've got dirt bikes flying through there, even 20 miles an hour, that's still a decent clip if you have children from a baseball running to their parents' cars. Wouldn't that make it even more of a problem?
Well,
which is why
if the dirt bike riding was prohibited there, I think that the cars parking there would be prohibited as well under that ordinance.
The ordinance, no, it says operation of motor vehicles. It doesn't say parking. It says operation of motor vehicles.
Wouldn't they have to drive there?
That's what I kept coming back to when I consired it. I mean, they have to drive on.
Is this also partly a disputed issue of fact, as whether there was negligence on behalf of the plaintiff by driving on an area where he shouldn't have been driving?
Yes, I think that's correct. It would be a disputed issue of material fact. I see am I over my time?
No, but you're getting close.
Okay. Thank you. I want to address the issue of Carriage Hill's negligence.
Well, then you are gonna be over your time, but that's okay. You better say it really quick.
Okay. We still contend that Carriage Hills can be liable for their own negligence. When you look at the contracts, the contracts showed that they directed Wolfer Landscaping to cut and blow and edge in that property once a month. But they didn't wholesale delegate maintenance for this swale area to Wolfer Landscaping. They were still exercising their discretion to, okay, occasionally when they need stumps removed, we know that within Carriage Hills, within the fenced, not the swale, but within Carriage Hills, that was outside of the contract. That was something that they would have done when they determined in their discretion that it was needed. And so we're as to Carriage Hill's liability, we maintain that they can be liable for their own negligence, not necessarily vicariously liable for that of Wolfer Landscaping.
Okay,
Thank you.
Good afternoon, may it please support Laura Wendell, Weiss Road, a Healthman on behalf of the City of
Are
Hollywood.
you all splitting your time?
We are. With me is Sharon Dagnan from Kubecki Draper. She represents Carriage Hill. I'm going to take 7 minutes.
Okay.
It's our joint position that there was no duty owed to the plaintiff by either defendant because the swale is an obvious hazard to dirt bike riding. And there was no summary judgment evidence demonstrating that either defendant had actual or constructive knowledge of the unintended use of motorbike riding so as to require
Well, how
them.
do you, I mean, there was testimony that there were people riding over it. Now, whether that constitutes constructive knowledge, you also have one of the city employees saying, yeah, we saw people, I mean, he was saying he parked there, so it was used for other purposes. But you do have the evidence of somebody who says, yes, they do that basically a lot.
Well, the law looks at unintended uses quite specifically. In the cases, the summary judgment was initially brought on unintended use cases. And in those cases, you don't broadly say, well, there are a bunch of unintended uses here, so therefore, this particular unintended use, of which there's no constructive knowledge, should be lumped in with those other unintended uses. So here you have a city employee who says trucks were parked on there. There is no evidence, and in fact, there's no evidence that trucks were parked on there at the time of the accident, which was in 2006 versus 2013 when the city employee testified.
Yeah, but if
But-
there are circumstances in the record where people are parking on it, that may have given people the impression that it was all right not only to park on it, but to use any other motorized vehicles. So is there anything in the record of do not park signs, do not park on the swale, any type of ticketing by municipal police, anything?
There are no parking signs. There were no parking signs at the time. There were, I mean, the case law says that you don't have a duty to warn of an unintended use. I mean, Wolf says that. Now, Grimes looks at constructive knowledge. Grimes goes a step further, but Grimes looks at constructive knowledge because in that case, it was a landscaped area and it was a well-worn path. I mean, there was no grass there. There was a garbage can there. There was an issue of fact as to the constructive knowledge of the parties liable, of the defendants in that case, because there were, it was practically self-evident
Well,
that
here we
that
have-
it was.
we
Here
have
we
a-
don't have any.
Well, but we have a deposition of a resident in the area says, yes, he sees ATVs going over there. We have the city employees saying, yes, they park there as a routine matter. And it's right across from a ball field. I mean, where people are playing ball. And I mean, it just that people park there all the time when kids were playing ball on the ball field. I mean, that goes without saying.
How can we have law that says you don't anticipate a pedestrian walking in a grassy area or in a landscaped area who trips on a route, And then we say, well, but this is a swale, so because it's a swale and it's a grassy area and there's going to be, it's not a dangerous condition as a matter of law that there is, now it's not a dangerous condition as a matter of law for cars parked there, that there was a short tree stump. It's only a dangerous condition as a matter of law for somebody who was riding a motorbike, and there's no evidence
what if
that
they were walking or running and hit it and injured themselves?
we don't have that case.
Well, but, I mean, you say it can't be anticipated. That you could be injured by a hidden danger, and this
Case
apparently
law
was.
says there's a
hidden.
sidewalk, where there's a sidewalk. I mean, Wolf said, well, it was determinative that there was a sidewalk there. And in Grimes, there was a sidewalk, but what was determinative in Grimes was that people didn't use it, and it was known that people didn't
Counsel,
use it.
wasn't the another determiner though in Grimes that they put the trash receptacle, required the person to walk into that area
It
to
was
get
so,
to
it was so well trodden and so well used that there was in fact a trash can there. We don't have any evidence like that. We don't have tire treads. We don't have, I mean, I don't know what an analogy would be to a garbage can, but we don't have like the grocery store cases. We don't have
Well, we have
tire
people
treads.
testifying, though, that people use this. Vehicles use this, pedestrians use this.
But it's not just a
Walked all
customer
over.
use, it's a customer use that if it is a customer use, and I think the testimony doesn't really rise to that level, and maybe that's the weight of that evidence. But let's say that there was a customer use, there still would need to be knowledge imputed through some kind of not a camera that monitors 24/7 if somebody's riding a motorbike over there, but imputed knowledge by evidence of tire treads. I mean, it's by the
Counsel-
grass being worn out, by the grass being,
What is your position of whether or not the plaintiff in this case was a trespasser or an invitee?
I'm going to defer some time to my colleague to address that more particularly. I would just say that under Wolf and under Grimes, there's no well-worn path here. Wolf didn't even care if there was a well-worn path there. In Wolf, there was knowledge of prior accidents of people walking through this planter and tripping. So Grimes takes the doctrine a step further because the knowledge is so clearly imputed of the particular use at issue. In that case, it was walking. Thank you.
Good afternoon. May it please the court. Sharon Degnan here on behalf of Kubicki Draper, representing the appellee Carriage Condominium Association. As the court knows, my client is the owner of the abutting property to where the swale area was here where this incident occurred. And we're here today, we join with the city in asking the court to affirm the summary judgment based on the legal proposition that there is no duty to maintain property in a manner in which it's not designed or intended. And that's different than the argument, the way the case has been briefed. It's a different legal proposition. And it's our position that, I mean, that's the basis, seemingly, that the court granted the summary judgment in this case.
So run that by me again, there's no duty.
There is no duty to maintain property in a manner in which it is not designed or intended to be used. And
That may be true, but what about if people decide to use it in a different way than what it's been designed?
there's an exception to the rule, and the cases are the Savignon case and the Ramadan case and the Dramstock case, and there's cases that recognize the exception is it doesn't apply here. It's where the property is customarily used in an unintended way with the knowledge of the proprietor, then there's a duty to either stop it or to make it safe for that unintended use. But that's not what we have here, because here there's no evidence at all that either defendant, and definitely not my client, had any notice or knowledge of how the property was being used.
Well, you
So,
say that, but I mean, again, we're here on a summary judgment. If
Right.
we were here on a trial and this is all they presented and the jury decided against them, that would be fine. But we've got a city employee who testifies that there are cars parked there, that he's parked cars there. We have other people, another person saying he's seen ATVs. Now, is that enough to say, well, it's still a question, a disputed issue of fact as to whether there was constructive knowledge that the property was being used for a purpose for which it may not have been intended? Although I don't know what you
Right.
use, a grassy swale, like other than parking and things like that.
well, there's plenty of cases that recognize it, and in fact, this context of not using a property for unintended use is the basis that these swale cases exist, because what they say is that everybody knows that a swale is not intended to be traversed on, which is why you don't have the same duty, and they're mainly municipality cases, and they say that's why you don't have a duty to keep it safe in the same way that you would on a sidewalk or an area where somebody is going to be walking. And one of the other big issues here, and Judge Buchanan, it goes exactly to your question, and I think it's a very, very big point here, is that the plaintiff was not an invitee on this property for the purposes of riding a dirt bike. And he admitted himself that during deposition, he admitted he had no permission from anyone to be there and that he was doing it for his own convenience, which is the definition of an uninvited licensee. And I
Well,
cited,
what would be the duty to an uninvited licensee?
much less
But what is
the duty is, I wrote it down so I'll get it right. It is to avoid willful or wanton harm, and upon discovery of his presence, to warn of known dangers not open to ordinary observation.
Okay, and the problem here is you've got a danger not open to ordinary observation because it was all covered up.
Well, it's not, but I think the more important point is that when you look at whether or not you're an invitee or an uninvited licensee, you have to look at the purpose for which the property is intended. And I think this ARP case that came out in April, when I saw it, I'm like, it's right on point in terms of when taught the basis. Are you familiar with the ARP case? That was the case where a plaintiff was walking through an area where there were paver stones backed by storm pumps. It was on an easement that was used by the city, and it was owned by a property owner. And there were a group of paver stones that were backed by the storm pump. And the plaintiff cut through those after she had been on a cruise. She cut through those pavers to get to her house as a shortcut home. And in that case, she had argued that, well, I'm an invitee and, there's a reasonable duty of care. And this court back in April found that, no, that when they looked at the definition of what the invitation test is, and I'd like to read, the invitation test bases invitation on the fact that the occupier, by his arrangement of the premises or other conduct, has led the entrants to believe that the premises were intended to be used by visitors for the purpose for which the entrant was pursuing, and that such use was not only acquiesced in by the owner, but that it was in accordance with the intention and design. And in finding that the plaintiff in that case was not an invitee, what the court found was, put simply, no one would reasonably believe that the area near the storm pump was intended to be used by visitors for the purpose which this entrant was pursuing, and that such was in accordance with the intention of design and the way that it was adopted or prepared. And that's exactly the situation we have here, where there's no view of the evidence that can show that the plaintiff reasonably could have thought, or a jury could reasonably find, that this was to be used for a dirt bike trail. So you do have to look at the activity that's being engaged in, because when I first looked at this case, I think that's the hard part, because they're all pedestrian cases. But to say, well, people are walking on it is very different than saying, was he invited on there to ride his dirt bike? And I'd submit that this ARP case really does stand for the proposition that you do have to look at the activity that someone's engaging, and just because somebody has parked on it or somebody has walked on it doesn't mean that it can reasonably be found that it's safe for what he was doing, or that they had a duty to keep it safe.
That's
for
interesting.
that.
I'm gonna have to look at that, because I think, to me, it sounds that you're parsing this much more finely than we've usually, the law usually parses landlord liability, where it's a discovered uninvited licensee.
I'd ask you to look at this case, because when I saw it, it's sort of, I think it's very, very
I don't remember that
applicable
one,
here,
but,
so.
but there's a lot of them I don't remember, so.
So, no, I agree, but Judge, I mean, and then again, I do think that my client is in a different position too in certain ways, and we did have raised an issue as to whether or not, here, the basis that the plaintiff is arguing that my client should be responsible is based on the city ordinance, and we cited to you the Shupak case and those cases that say that that doesn't create a private cause of action in tort. It doesn't give rise to a duty in tort just by virtue of the fact that the property wasn't maintained consistent with the ordinance. And I would submit that the cause of action that's been brought against my client is not for active negligence. It was based on the vicarious liability of the contractor, and we'd submit we can't be responsible for that.
Okay,
So
thank you.
we'd ask the court to affirm.
A couple more minutes, you've gone over, but I let them go over, so I'll give you a couple more minutes.
Thank you, Your Honor. As to, counsel mentioned what was determinative in the Grimes case. I think Grimes is pretty clear that what was determinative in Grimes was that there was evidence that the area in question was being used for foot traffic. In the same way, in this case, we've got the evidence, and you can argue about the weight of the evidence, sure.
The case the council was mentioning.
Arc.
To be honest, I'm not familiar with
It was the notice of supplemental authorities that they filed after we granted oral argument.
I'd be happy to do a supplemental brief if the court would.
No, don't do that. We'll take a look at the case. Okay.
Yes. Now, as to whether Mr. Ehlers was a trespasser, our contention is that he had given the summary judgment evidence that we've got, that he was an invitee, a public invitee by reasonably implied invitation based on the evidence of what people were using this property for. And again, this was not a landscaped area, separated off. It was the swale right across from the baseball diamonds, and we have evidence about what it was for. And then finally, I'll just stress again that the cause of action against Carriage Hills is not based upon their vicarious liability. They clearly took action to maintain the swale, but then did it in such a way that they allowed this dangerous condition to exist on the property. So, unless there's any more questions from the court, I'll respectfully ask for reversal. Thank you.
Thank you very much. That concludes our docket for today, so for